purpose of my talk today is to talk about the principle of open justice and the permissible derogation from that principle under Rule 94 on the grounds of national security. But in addition to that, whilst that will be the main focus, I'm going to touch on briefly some of the case law, not all of it that's contained in your handouts, but some of the case law that has developed over the last year or so in relation to Rule 50. But at the start, it's probably worth reminding ourselves about what the principle of open justice is all about. It is that justice should be done, but it also should be seen to be done. And the handouts begin at page 25 in relation to this particular topic. And you'll see there on page 25 an extract from the Supreme Court decision in Dring from 2019. And in that case, Baroness Hale explained the main purposes of the open justice principle, and those purposes are twofold. Firstly, to enable public scrutiny of the way in which the courts decide cases and to hold judges to account. And secondly, to enable the public to understand how the justice system works and why decisions are taken. Now, obviously, in order to do that, the public need to understand the nature of the case, the issues, and the evidence. And in most cases, as we'll all know, dealing with Employment Tribunal cases, it's nigh on impossible to understand the issues in the case and what the case is about without sight of the written documents that support it. And that second part and rationale for the open justice principle brings me to the decision last year of Guardian News and Media and Rosanoff, because that second element has particular implications for press reporting and publicity. Now, Mr. Rosanoff had brought a whistleblowing claim involving serious allegations against his former employer, EFG Private Bank. And under normal circumstances, as we all know, during the course of an in-person and attended Employment Tribunal hearing, the press would have access to the witness statements, they'd be able to see the statements of case, they would be able to see skeleton arguments from the final hearing and so on. But in this case, the Guardian hadn't got anyone present at that hearing. And so almost 2 months after the judgment was promulgated, the paper applied for copies of not just the ET1 and the ET3, but also a schedule of over 50 documents that had been referred to in the judgment, in the decision of the Employment Tribunal. Now, when they considered their application, the tribunal allowed it in respect of the ET1 and the ET3, but refused the application in relation to all of the other documents. And in so doing, what they said was that they didn't feel that the principle of open justice was strongly engaged in this case, and they also relied on the cost and inconvenience that would follow if some 2 months after the judgment, either the respondent or the tribunal was required to trail through old bundles and find the necessary documents. Perhaps understandably, the Employment Appeal Tribunal disagreed with that and said that the decision was fundamentally flawed. One can understand that in light of some of the allegations. One in particular was that an employee of EFG had aided attempts to facilitate a large transaction from an associate of a person who had been accused of serious human rights violations. So clearly, the open justice principle was engaged. And the EAT also rejected the argument put forward that in relation to cost and inconvenience, and held that the tribunal had been wrong to give that more weight than the principle of open justice. The judgment is interesting because it emphasises the fact that one of the crucial features of the open justice principle is that the public are able to understand decisions that are made and the reasons for them. So in terms of the default position in the Employment Tribunal, it is set out in Rules 56 and 59. Final hearings and any preliminary hearing that disposes of an issue, so for example a strikeout application, must be in public. And derogations from that principle can only be justified when strictly necessary to ensure the proper administration of justice. The case of Amia that you see on the slide that's in your handouts sets out helpful guidance as to the approach that should be adopted. Specifically, first, the burden of establishing any derogation rests with the party seeking it. It must be established by a reliance on clear and cogent evidence, and on that point I'm going to speak about some of the recent case law. And of course, sometimes in employment tribunal proceedings, we all know that in order to reach a determination on the issues in the case, it often involves airing and considering damaging allegations upon which the employment tribunal do not have to adjudicate. And what the EAT said in AMIA and PwC is that the employment tribunal should be able to credit the public with the ability to understand that unproven allegations are just that. And any risk of misunderstanding can be mitigated by the tribunal when they deliver their decision and reasons. But an interesting development in relation to that point was the case of Bloomberg and ZXC last year. Again, another case that went before the Supreme Court. And it was a successful claim brought by the employee that Bloomberg had misused private information arising out of an article published by them relating to activities which led to a criminal investigation. And the Supreme Court upheld the decision of the courts below that a person under criminal investigation has a reasonable expectation of privacy until such point as he or she is charged. And then in this case, ZXC's Article 8 rights outweighed competing convention rights in terms of Article 6 and Article 10. Now, why that case is interesting is it is in slight conflict with the case that many of you will be aware of Kuja and the Times newspapers. Again, another decision of the Supreme Court in 2017. That concerned Operation Bullfinch, which was a police investigation into child sexual exploitation. And one of the complainants had identified an individual who was arrested but subsequently never charged. And the Supreme Court in that case had upheld the High Court's refusal to make an order protecting that person's identity on the basis that I've already outlined, that the public should be credited for understanding the principle of innocent and proven guilty. So we will see what happens in future months, years to come in terms of how that principle develops, given the potentially conflicting decisions. So moving on to Rule 50 itself, you can see there that Rule 50(1) identifies 3 grounds upon which a derogation may be made. Firstly, if it's in the interests of justice. Second, to protect a person's convention rights, commonly Article 8. But of course, in making that decision, the tribunal has to balance any competing convention rights under Article 6, right to a fair hearing, and Article 10, freedom of expression. But also another ground of derogation under Rule 50 is in order to protect confidential information. Now, your handouts set out the different types of order that can be made. I'm not going to go through all those. They range in severity from anonymity orders and redaction right up to hearing part or all of the proceedings in private. But what I want to go on to discuss is some recent cases that considered applications under Rule 50. And first, I'm looking at 2 cases, Piepenbroek and the Isle of Spa case, both from 2022, which were cases involving orders to protect convention rights, and in these cases, Article 8 rights to privacy and family life. Now, again, because in terms of time constraints, I'm not going to go through all of the facts of those cases, but what both of them demonstrate is that point that clear and cogent evidence is required to be successful in a claim, an application under Rule 50. The tribunal simply shouldn't nod these applications through, even if they're agreed between the parties. And in Piepenbroek, you'll see the facts of that case in your handout, but effectively the person protected by an anonymity order was a third party in Employment Tribunal proceedings brought by Mr. Piepenbroek. She had complained that he had harassed her during the course of her employment. And Dr. Piepenbroek, I think it is, had made false allegations against her, that she'd made it up, that she'd admitted making it up, and that, in fact, she had harassed him. And he went on to do things such as setting up a website, naming her and making derogatory remarks about her. And obviously, we can see from the handouts, the EAT concluded that her Article 8 rights outweighed any other considerations. And what was particularly important in that case is that she had provided very compelling evidence as to the effects on her of the existing publicity surrounding the case, but of further publicity. Similarly, in Isla Spa, that involved another example of a successful application to protect convention rights where Article 8 is engaged. And again, in that particular case, you'll see from the facts and the decision of the EAT, there was really very compelling evidence about the effect on that particular third party. It included, for example, a witness statement as to the effect on her mental health, but also her reputation. She'd provided evidence that she'd conducted a Google search in her name, and the first thing that popped up was this particular judgment. So that was a key factor in relation to the decision of the EAT. Going on to one of those other grounds for derogation under Rule 50, to protect confidential information, is the case of Frewer and Google, again from last year, decision of the EAT. Now, this is a judgment that's particularly instructive, I think, in terms of if you're representing businesses who are understandably perhaps concerned about confidential information coming out in the course of evidence and seeking to protect the interests of their clients. Now, Frewer was a whistleblowing claim brought against Google where the claimant had said he was dismissed because he made protected disclosures about anti-competitive behaviour of Google. And part of that anti-competitive behaviour was that Google favoured two of its major clients in the travel industry. And the decision of the EAT, again, provides really helpful guidance on the approach that parties should take to both disclosure, first of all, and then redaction. So the first point to note is that in the EAT, Google had successfully applied for an anonymity order for multiple client names, including the two clients it was said to have been favouring through this anti-competitive behaviour. And bearing in mind those allegations, unsurprisingly, the EAT said that decision couldn't stand and remitted the matter back to the tribunal in order to determine whether, if there were genuine issues of commercial confidentiality, some or all of Google's clients should be anonymised. But the EAT was very keen to stress that they very much doubted whether the anonymisation of the two major clients could be justified. But secondly, of practical assistance, I think, to us as employment lawyers, is the guidance given in terms of, first of all, disclosure. Now, Google in the tribunal had successfully applied to redact up to around 3,000 pages of commercially sensitive and in some cases irrelevant information. And again, the EAT remitted that, saying it couldn't stand, and set out at paragraph 47, which you'll see is referred to in your handouts, really a first principles approach that parties should take when they're approaching disclosure. Firstly, in terms of relevance of documents, looking at it in its proper sense, whether it undermines a party's case or assists it, and whether it's necessary for the fair disposal of the proceedings. If it doesn't do any of those things, then there's no need to disclose it. And obviously in this case, there was some irrelevant material that had subsequently been redacted. And only if that material is relevant should a party then go on to consider an application under Rule 50. Finally, on Rule 50, I'm going to touch very briefly on this case, Clifford and Millicom, hot off the press from December. This was a Rule 50 application brought under all three heads: interest of justice, convention rights, and protection of confidential information. The facts are fascinating. I'm not going to go into those, but what I will say in terms of takeouts from that judgment is the interplay between an application on an interest of justice ground and an application on the basis of convention rights. And for example, whilst derogations on the grounds of interest of justice were often said to walk in step with convention rights, it wasn't always the case. And the common law's protection of the fairness of court proceedings extends to the protection of life and limb for those people who live outside the jurisdiction of the ECHR. And again, the difference between interest of justice and convention rights applications is that in this case, the subjective fears of witnesses, in this particular case, the second respondent who had overall control of the litigation was one of the directors who had said that if the applications for under Rule 50 were not allowed, then neither he nor the business would proceed with defending the case. Because so scared was he of the potential implications in terms of risk to life and limb of employees in other countries. And so what the EAT said is that under an interest of justice application, subjective fears could be taken into account in contrast to an application brought to protect convention rights, which had to be objectively justified. So again, quite an interesting case if you've got the time to look at it. So I'm going to move on to now look at applications under Rule 94 on the grounds of national security. The Employment Tribunal's duty is set out under Rule 94.10, and that is to ensure that in exercising its functions, information is not disclosed contrary to the interests of national security. We can see there some of the available orders under Rule 94. Some of them are familiar. They're identical to some of the orders under Rule 50, an order that proceedings can be heard in part in private, for example, or anonymisation. But what is different about Rule 94 in terms of the types of orders that can be made is that we see in the second bullet point, the incredibly draconian power to exclude a party or a person from all or part of the proceedings. As I say, that couldn't be more draconian and could be more offensive to the open justice principle. Now, Rules 94.1 and 94.2 are set out in your handouts. And I suppose the first thing to note about Rule 94.1 is that in principle, it allows a minister to direct a tribunal to make one of the orders that we see. Now, to my knowledge, that power has never been exercised, and perhaps that's understandable given the draconian nature and the scope for an immediate challenge on judicial review. So that leaves the tribunal's powers under Rule 94.2. Any application for an order has to be made in private. It will be heard by a special panel appointed under Regulation 7 by the President of the Employment Tribunals. And because of the nature of these applications, it will ordinarily be transferred to London Central to be heard, which is where the judges with the national security ticket sit. So you may come across these applications in claims involving people who work for government organisations, for the police, and the other people who are bound by the Official Secrets Act. What is important to note is that under Schedule 8, the Employment Relations Act 1999, members of the Security Service, members of the Security Intelligence Service, and employees at GCHQ are prohibited from bringing whistleblowing claims. But save for a couple of exceptions, other Crown employees may now do so post-1999. The powers under Rule 94 can only be exercised where it is expedient in the interests of national security, not necessarily in the public interests. And I suppose a distinction in relation to national security versus public interest would be perhaps if you represent a police officer or you're a force solicitor working for a police force or a chief constable, and there is an application for a closed material procedure on the grounds of public interest immunity, perhaps to protect the interest, revealing the identity of an informant, or police tactics in relation to organised crime and things like that. That would not fall under Rule 94, which really is just to deal with matters in order to protect national security. Now, I just want to go back to, I should say, if the order is granted, there is a separate set of rules of procedure set out in Schedule 2 to the Employment Tribunal rules that the Tribunal will need to follow. But in terms of the really draconian power to exclude a person or a party from part or all of the proceedings, the question which undoubtedly arises is how can that power conceivably be compatible with the right to a fair hearing and with Article 6? Well, the Supreme Court has said it definitely is compatible, and your handouts contain an extract from the judgment of Lord Justice Mance in Tarrick and the Home Office. And in that case, the Supreme Court acknowledged that the closed material procedure should only ever be contemplated or permitted by a court if satisfied after inspection and full consideration of the relevant material, as well as after hearing submissions from the special advocate, that it is essential in the particular case and it must be kept under review throughout the proceedings. Tarrick was an immigration officer who was employed by the Home Office, whose security clearance was withdrawn because a member of his family was arrested and then subsequently charged with a terrorist offence. And he brought proceedings for race and religious discrimination against the Home Office, who denied the allegations. And they obtained various orders, which included the exclusion of Mr. Tarrick and his representative from part of the proceedings when closed evidence was being considered. And in that case, the court held that Rule 94 did not remove the substantive rights conferred by the various discrimination directives, but simply modified the procedure for enforcing those. And ultimately, it was because of the protections that were in place, and as we'll come to discuss in a moment, in respect to special advocates, there were sufficient protections in place. So first of all, how should a tribunal approach an application under Rule 94? And Mr. Justice Underhill, as he was then, gave guidance, both guidance as to the approach to be adopted, but also practical tips, effectively, for advocates in how to deal and navigate these really difficult applications, because let's face it, getting it wrong has profound, or could have profound and very damaging implications that extend beyond simply winning or losing a case. So in terms of guiding principles, similarly to Rule 50, an exception to the rule of open justice must be justified, and there is a heavy burden placed on the applicant in respect of that. It involves the usual balancing act, balancing the prejudice to national security on the one hand and to open justice on the other. And the Supreme Court emphasised that the more serious the infringement of the principle of open justice, so for example by exclusion of a person from proceedings, the greater the prejudice or risk of prejudice to national security needed to justify it. The court recognised that the interests of national security are a little bit different from perhaps other applications for a derogation, for example, under Rule 50, because the stakes are very high and involve very real risks to the security service and other people. The court said that these risks weigh very heavily in the balance, in the opposite balance against the principle of open justice. But that said, the court went on to say that the tribunal can't abdicate its responsibilities. It still has to perform that proportionality exercise. In terms of practical considerations, the first bit of guidance given by the court was really don't proceed too early with these applications. In order to be able to either make an application and certainly for the tribunal to make an order, we need to understand what is likely to be canvassed in evidence and therefore what information needs to potentially to be dealt with by way of a closed material procedure. And Mr. Justice Underhill then identified a very practical way of the tribunal dealing with that type of application. First, he suggested that the respondent could be required to identify in a schedule the facts which were said to be sensitive, together with its proposals as to the steps necessary to prevent disclosure. And then secondly, following on from that, for the claimant to then provide effectively a counter schedule on an item-by-item basis, saying whether she accepted the restrictions, and if they didn't accept them, any alternative proposals as to the form of any protection needed in respect of national security interests. So where an order under Rule 94 is made, the normal rules don't apply, as I've said. Schedule 2 to the 2013 rules do apply. If a party is excluded, there needs to be the appointment of special advocates, and their role is to represent the excluded party, both in cross-examination under a CMP, even if non-disclosure is maintained, to do whatever they can do to protect the interests of the claimant. The special advocate can communicate with the claimant before they receive closed material, but not afterwards, unless they've got permission from the tribunal. And in granting that permission, the tribunal has to first consult the minister as to their views on whether they object to further communication. The special advocates, in particular in relation to Rule 94, represent the real final safeguard for the excluded party in terms of their right to a fair hearing. And in Tarek itself, the Supreme Court alluded to the crucial role that the special advocate may well have played in that particular process. In that case, full reasons in relation to the decision were released 10 months after redacted reasons were initially sent to Mr. Tarek and his representatives. And the Supreme Court suggested or alluded to the fact that the removal of those redactions when full reasons were given may well have been because of that central role of the special advocate. So to summarise, clear and cogent evidence is required whichever application is brought to derogate from the principle of open justice. The application should be closely scrutinised, and ultimately the reason for that is set out or alluded to in Dring by the Supreme Court, who cited the judgment of Lord Shaw in the 1913 case of Scott and Scott, and in particular the words of Jeremy Bentham. Publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all grounds against improbity. It keeps the judge himself while trying under trial.